When is it time to object in a probate case?
Objection, Your Honor. That's hearsay.
I'm not talking about objection, Your Honor. I'm talking about filing objection when someone doesn't agree with what's going on in the probate case. Hello everyone, my name is Joseph Radzwion IV, your trusted attorney with Radzwion Law, PLLC, and I'm a licensed attorney here in the state of Michigan that regularly practices probate law. If you stick around to the end of this video, I have some good examples and a pro tip that'll help on this topic. What is that topic? This topic that we're talking about in this video, in simple terms, is objections. An objection in probate is not the same as what we see in the movies, but it's essentially a way for someone to tell the judge that there is a person who doesn't agree with what's going on in the probate case. That's the easiest way to explain it. The objection can be filed, or an objection can be filed for just about any reason. The majority will be that an objection is filed when a petition has already been filed by someone else, and the person that's going to object is reading that petition or that court filing and saying, yeah, I don't like what's going on here. I'm going to let the judge know. So they write their objection and they file it with the court. Typically, the court is going to require someone to pay $20 to file an objection. That's pretty standard. It's a nominal fee. Some court costs may vary. Again, this is specific to Michigan law. Common reasons for someone filing an objection would be they don't agree with who's been proposed as the personal representative. So let's say Uncle John files a petition, says he's going to be listed. He wants to be named as the personal representative. Aunt Sally disagrees, so she files her objection to let the court know, hey, you know, we're not all the interested parties, not all the heirs of the estate are on the same page here. Another common reason for an objection being filed would be once a personal representative is appointed, they are tasked with the duty of listing all of the valuable items in that estate. You know, bank accounts, valuable cars, property, you know, gold bars, diamonds, jewelries, whatever it may be. And someone may look at that inventory after it's been filed and say, you know what? I don't think that they have everything. I think that Grandma had more jewelry that should be listed on here. Another common scenario there is maybe all the jewelry was listed, but Aunt Sally's going to say, nah, that jewelry is more valuable than what Uncle John has listed it for. So I'm going to object. And then the last kind of big area people will object to is when real estate or, you know, property is being sold. Maybe it's a house, maybe it's a up north cottage, that sort of thing. The two objections there are they don't want it to be sold for whatever reason, or, you know, Aunt Sally is objecting, saying Uncle John should be trying to sell that property for more than what he has it listed for. So those would be common scenarios where objections would be filed. Those are the biggest ones that we see. But again, objections can be filed because maybe an accounting has been done wrong, or something wasn't reported in an appropriate way to the court. So let's talk about what happens when an objection is filed. The court should be looking at that objection going, okay, the parties here are not on the same page. Maybe there's more evidence that needs to come to light. So what the court should be doing is setting what's called an evidentiary hearing, or at the minimum, some sort of status conference to see what the parties are thinking. Just depends on the case there, but most of the time an evidentiary hearing will be set. And if an evidentiary hearing gets set, it will usually get set for weeks, even sometimes months after that first hearing, you know, of what the person is objecting to. It's going to be several weeks, if not months later down the road. We're going to cover evidentiary hearings in another video and, you know, how serious they can be. Let's talk about when we're filing an objection. An objection, the timing of it is going to be someone will want to file one immediately upon learning of the evidence that they disagree with. So let me say that again. The person that's filing the objection is going to want to file it as soon as they get the information that they say, I don't agree with that. And there are a couple reasons for that, but the biggest one is there are going to be court rules that say you have a specific amount of time to do that objection. The other thing would be is if Uncle John sells that house, but Aunt Sally has objected to the purchase price, once that house is sold, it's very hard to undo that sale, and the court might not even entertain that idea. So the thought is once someone doesn't like the information that they've just got about that probate court or the probate case or what's happening in it, the objection should be being filed. In general, after an objection is filed, the court should be essentially pausing the case and saying, all right, let's look at what's going on. We'll pick a new day that the parties can agree on. But if you or someone you know has filed an objection with the probate court and they have not set an evidentiary hearing, you should be getting a hold of me immediately because your rights may be being violated by the court. The other reason to get a hold of me would be is if you have an evidentiary hearing set up, you don't know if discovery has been open or if you have the appropriate information that you can submit to the judge to help assist your case. You'll want to get a hold of us immediately if those are the situations that you're in. And I will again cover the evidentiary hearing, which is like a trial, in another video. Now that you've stuck around to the end, we're going to give you the pro tip for our topic today. And that is when an objection gets filed, someone who's showing up to court to explain, yes, I've filed an objection. A lot of times that person is going to want to get into the nitty-gritty details, and that is not the hearing at which that person is going to be given an opportunity to do that. So what I tell my clients when we're going in front of the judge, this is what's going to happen. This is the judge's expectation. This is what is likely to occur. I prep my client to understand when the judge asks them, who are you? It's your turn to talk, essentially. My client knows, okay, my name is Aunt Sally. I'm here because I disagree with Uncle John, trying to sell the house. We filed an objection. We would like an evidentiary hearing set. Please give us more time to do that evidentiary hearing and collect the evidence. And then Aunt Sally knows, because I've told her what the expectation is. Hey, you can answer any questions that the judge has, but you're not going to get into the facts of what your case is at that hearing. It's not the appropriate time. So many times I'm sitting in the courtroom and I'm waiting for my case to be called, where other cases are being called, and I'm listening to these people talking about their case. And the judge is like, it's not time to do this. Why are you fighting? Just a couple weeks ago, I watched a lady talk about how her sister had been not doing what mom wanted, and she was taking care of mom, and she knew what mom really wanted, and it was that she was supposed to get the house and the other sisters weren't supposed to get the house. And the judge is like, everyone needs to just step back. We're going to set it for an evidentiary hearing. But this lady just kept going and going, and she didn't understand that's not the time to explain the case to the judge. She doesn't have any witnesses. She didn't have any documents submitted. She didn't have anything really to prove her case other than her just ranting about her not liking her sisters and what they did with mom. So that is your pro tip. Don't tick the judge off. Just show up, tell them who you are, tell someone that's filed an objection. The person is telling them who they are, how they're related to the case, the objection's been filed, and that they'd like an opportunity to have an evidentiary hearing. So if you have questions about objections, evidentiary hearings, or anything to do with the probate process here in the state of Michigan, please get in touch with us. We would love to help you. You can do so by clicking on our website link in the description box below. It will bring you to our page where at the very bottom it'll have the Get in Touch box, and that box will you fill out your information there, and you can communicate with us directly through that. If you have questions about evidentiary hearings, you can click on the video here, and if you have additional questions on how to open a probate estate, you can click on that video here, and we will see you in the next video. Thanks again for watching, everyone, and we will see you next time.